Just kidding. Hopefully it's working today. Yesterday was a little bit of a doozy, but we reconfigured a couple things here, and we're hoping we're coming in loud and clear. So let me know if you can hear us, and more importantly, let me know if you can hear us right now as we're watching this. If you can continue to hear us, then it should be working, and we'll get into business on the day. Now, we, of course, as you can see, we're still in Washington, D.C., and and the morning was amazing. So your boy was out this morning, did a walk and talk. I wanted to get it posted before we went live today, but alas, the upload speeds here are quite rough. And so it's uploading right now, and my team on the other end is going to help me get those published. But let me just give you a quick show around. Here's what we had this morning when your boy was walking around. You could see, hopefully you can see all this. In fact, let's just pull this over here so that we can see it here. And so this was your boy walking around. So this will be coming out later a little bit, but we walked around, went down to the Supreme Court, got to check that out, and then went over to the Capitol building. So this is walking around the Supreme Court. It was an awesome morning. We talked about Emil Bove. We talked about Chuck Grassley. We talked about a bunch of other things. And then, you're not going to believe it, but the camera started to overheat and it just started to crash out. So right as about we got to the Capitol, it started to crash out. I got it going for another couple minutes at a time, but we were right there, my friends, this morning. And so we'll be publishing that in just a little bit, but I just wanted to let you know that that was coming out, and it's been a lot of fun. So hopefully you could see all that and you get a chance to watch that one, because Washington, D.C. is pretty amazing, and it's a cool place. So very cool to be here. It's National Whistleblower Day today. Shout out to our whistleblowers. We'll be meeting with our friends at Empower Oversight. We've had them on the show, I think, 3 times, and they were the lawyers behind the IRS whistleblowers and the Hunter Biden stuff. And it was very important to have their voices this last election, because they were trying to sweep all that stuff under the rug and basically hide all of the Hunter Biden stuff. So we got a little celebration today that will be celebrating the IRS whistleblowers and all of the other brave whistleblowers that are out there. And Chuck Grassley will be in attendance tonight. Your boy's very excited about that, but there is a tizzy brewing over between Trump and Chuck Grassley. Of course, Chuck Grassley, we know and love here, and he is one of our favorites, and your boy's just pulling this up to make sure that we are functional on our channel. Looks like we're live over there. And all right, so here's what we've got. Now let's zoom this puppy in over a little bit here. I forgot my screens are kind of wonky on this. All right, so let me just figure this out real quick. This is the joys of new setups when you're on the road trying to figure it all out. All right, so here is this one. Here's the battle that we've got now that is brewing. And you can still hear me. Amazing. There's an echo. All right, hopefully it's okay. All right. Anyways, so here's the story that's brewing. So Chuck Grassley and President Trump getting into it. We like both of them, and so we hate when there's this intra-party warfare that is going on. But what you see is Trump posted this, and I referenced it in the other video, so you'll hear me read it again in that video. Chuck Grassley, he says, the president, who I got reelected to the U.S. Senate when he was down by a lot in the great state of Iowa, could solve the blue slip problem we're having with respect to the appointment of highly qualified judges and U.S. attorneys with the mere flick of the pen. That's all Chuck has to do. And he hasn't done it yet, says Trump. Now, put simply, here says, Democrats like Schumer, Warner, Kaine, Booker, Schiff, and others, sleazebags all, have ironclad stoppage of the great Republican candidates. Put simply, the President of the United States will never be permitted to appoint the person of his choice because of an ancient and probably unconstitutional custom. It is really, in a way, giving Democrats a pocket veto power over these U.S. attorneys. And in the situation like we saw with Alina Abba, she was also stopped by judges. Basically, 15 of the 17 of them were Obama or Biden judges, and they all prevented her from maintaining her position, picked someone else, they fired that other person, Desiree, and we know the story. So probably unconstitutional that if you have even one person in the opposite party serving in the Senate, he or she must give consent, right? So for Alina Abba, it's Cory Booker and it's Kim, thereby completely stopping the opposite party's nomination. The only way to beat this hoax is to appoint a Democrat or a weak and effective Republican who they like. Therefore, I would never be able to appoint great judges or U.S. attorneys in California, New York, New Jersey, Illinois, Virginia, and other places where there is coincidentally the highest level of crime and corruption. They need good people the most. The place where fantastic people are most needed. Senator Grassley must step up, like crooked Joe Biden did when he openly broke at least 2 times the blue slip scam, and like others have done over the years, and let our great Republican judges and U.S. attorneys be confirmed. He should do this immediately and not let the Democrats laugh at him and the Republican Party for being weak and ineffective. The Democrats have broken this ridiculous custom on us. It's time that we speak it on them. Chuck, I know you have the courage to do this, so do it. And, you know, it's a very Trump-y statement. I'm not sure that Chuck Grassley is the right target for that, because Chuck Grassley has been in Trump's camp a lot. In fact, I think Chuck Grassley dug his heels in and made sure that Emil Bove got out of committee. And remember, the Democrats stormed out of the Judiciary Committee on that. And Cory Booker was doing his thing. He's still talking. No one cares. Cory, it's over. Turn the lights off. Janitor's here. We got to go home. So he just kept going. And Grassley, I think, has been a very, very effective figure also in the whistleblower stuff and releasing documents to us. I mean, like half the documents we read here come from Grassley's office. So he's been, I think, a very useful ally. I also think that the Democrats play a different game when it comes to the judiciary and to judges and U.S. attorneys. They know that that is a very powerful institution. They're not giving up that mound without a fight to capture that flag. So if you're going to come in and try to mess with that, they'll go nuts. They'll even backstab you. And I referenced this in the video from this morning, so let me say it again. But remember when the Democrats said, we'll give you some Court of Appeals judges. They're going to retire if you give us these other lower level district judges because they're going to stay here. And it's all going to be even Stevens. And then as soon as Trump won, all of the retiring appellate judges all reversed their retirement and were going to carry out the rest of their terms. And so the Democrats kept all of the district judges and all the Court of Appeals judges because the Republicans gave up the lower level picks. They picked them, filled them, and then they unretired. So the Republicans, and they kind of just sit there like, whoa, Democrats, good thing we're not like them. It's like, well, they're playing the rules, man, and so no one's indicting them. So if these are the rules, then you guys should play by the rules, and you guys should get very aggressive with this stuff. And Chuck Grassley, right, could do that, certainly. He could push these people through and get a little bit more aggressive with it, but we'll see if that happens. Doesn't look like it's going to. Chuck Grassley didn't take kindly to those words from the president. He was out this morning. He said, today, right around the corner, I was standing right outside when he was in there, probably ripping the president. He said, I'm pretty offended by what President Trump said about me. It's ridiculous.
Last night, I was surprised to see President Trump on Truth Social go after me and Senate Republicans over what we call the blue slip. Now, to people in the real America, not here in this Washington, D.C. and island surrounded by reality, the people in real America don't care about what the blue slip is, but in fact it impacts in their states the district judges who serve their communities and the U.S. attorneys who ensure the law and order is enforced. I was offended by what the president said, and I'm disappointed that it would result in personal insults. Now, we're here to do business. That's a very important part of this committee's work, to do our constitutional duties of reviewing people that require Senate confirmation. Good morning.
Okay, so sorry about the volume on that. Was that very loud? So Chuck was blowing out everybody's eardrums. Well, he's not happy, so my apologies for that. Neither is he. And which is what I said. So, Chuck, I understand it's a Trumpian post, but he's not, I think, really trying to insult you. It's just kind of a Trumpy thing. So, hopefully they can mend the fences on it. And Chuck Grassley, it's just Trump being Trump. It's not, don't take it personal. It's just how he talks about everything, everywhere, all the time. Happens to everybody, even his 2-year-olds, right? When he had them, like, I can't believe little Donnie would do something so reckless and pathetic and not, whatever. So you get the point. So that's happening, and we'll keep our eye on that. So that's warming up things over on Congress. But we've got some other big business that is happening today. So we've got some serious updates here in both cases. Big updates from the Department of Justice in both of these cases. The Maxwell and the Epstein case both got new filings. You see memorandums in support by the USA apparently came skidding in last night like at 11:59, 11:58. People were watching the docket. And that was the deadline. And so we got now the memo that has come out from the Trump Justice Department in an effort to unseal the filings in both cases. So from the grand jury proceedings that we've talked a lot about. Now, what happened in both of those matters before we get to Trump's response is the courts came down and they ordered the DOJ to basically give us some more information. They said, if there's rules about this, and if you're going to unseal anything in a grand jury transcript, you got to give us, indicia. Like, why should we do it? Are there any exceptions? What is the public interest, if you say? Why is this important? What are the privacy interests of the people who are involved? Are there any other continuing cases or co-conspirators or victims' rights? Have they been complied with? All these things. So lots of questions. And what we saw from the Trump DOJ almost felt like kind of like a token motion to unseal, right? Just kind of filed it. All right, public screaming about it. We'll file it, whatever. And it was pretty bare bones. I think it was 4 pages in total on both cases. We read through them. Maybe a little bit longer than that, but nothing, not a 30-page burner or anything like that. So it was pretty small. And then today, in response to the court orders, we're saying, okay, well, they'll just beef it up in these filings, and so let's see what's inside. Now, this filing was submitted in both cases, substantively the same thing. You see, it's the Jeffrey Epstein and the Ghislaine Maxwell case. This is the government's response to the court's orders, where the judges came back down, and we did a prior video on this where the judges just said, fill this out, essentially. Give us more details on this because it's pretty bare bones. So this is coming in from Jay Clayton, right? So he works under, it's Pamela as the AG, Todd Blanche, the deputy AG. Todd Blanche is the guy who went and met with Ghislaine in the prison. And so under him is Jay Clayton. Jay Clayton's going to be the author of this, and a little bit more about Jay Clayton, which is interesting, is that Trump has nominated this guy a couple times to a couple different things. So he's been around a while, but he's also a Bill Barr protege, which is curious. On January 4th, President-elect Trump announced this guy, this U.S. Attorney Clayton, to be the SEC chairman. And he was nominated on Inauguration Day. And then the Senate voted him in, and he was sworn in and became the chairman. Then after the SEC, he went out and worked at the Apollo Global Management Board, right? Lead independent director on the board. So he's like a finance guy, right? SEC, finance guy. Then he rejoined Sullivan and Cromwell, became a senior policy advisor, independent board of directors, and all of these things. Like, this dude is super accomplished. He's done a bunch. He's consulting. He's getting $500,000 a year for some sort of consulting fee, and has been the chairman of the SEC, all these things. Like, what is he doing as a U.S. attorney prosecutor for the Southern District of New York? Oh, well, it's the Southern District of New York, baby. That's Wall Street. You know how much money's there? You know how much power this dude and leverage this dude has based on his connections with Apollo Global Management and all these things? So in March, Clayton joined as an independent member of a board, and then this last was selected on November 14th, 2024 by Trump to be the U.S. attorney for the Southern District of New York, right? So he came in, and prior to that, so he's a finance dude. Now, prior to that, on June 19, 2020, so nearing the end of Trump's term, Biden's about to come in, Attorney General Bill Barr, you remember him, who said Epstein killed himself like 5 minutes after it happened, saying that Trump would nominate Clayton to replace Jeffrey Berman. Okay, there was another U.S. attorney there, this guy, and he was kind of fired / resigned. Remember, after Epstein died, about a year went by, and then Bill Barr came out and said, Jeffrey Berman is no longer here leading this district. And what? And he wrote another response. He said, yes, I am. You can't fire me. And then Trump ultimately had to come in and settle the squabble, and he did. He came back and then ultimately fired Berman. And Berman then went and worked for some private firm, wrote a book about it, which I need to read, and he then was theoretically going to be replaced with this guy back then, June 9, 2020. So it sounds like Clayton then, he was going to replace Berman. However, he was not selected. They went with Audrey Strauss. She became acting. And then Clayton resumed his path to the role when Trump announced he would be the interim U.S. attorney for Manhattan. Now he's going to assume the role officially pending confirmation by the U.S. Senate. So pretty interesting. They're finance people. Clayton's wife, Gretchen, whom he started dating while they attended the same Pennsylvania high school, worked at Goldman Sachs. Clayton's wife resigned from her job prior to the confirmation. Yeah, because Goldman Sachs is in the Southern District of New York. So pretty interesting prosecutor for them to put on this case and to have him filing this. We'll see if there's anything more that comes of it, but that's him, Jay Clayton, and yeah, this guy right here is what he looks like. Assumed office, now he's over there and been around a while. So he sent this one in for both the Gullin and the Epstein cases. He said, all right, the government respectfully submits this memo. I know, Judge, that you told us you wanted additional information. Here we are. Responding to your court's orders concerning the 2 pending motions that we filed to unseal these grand jury transcripts, one in the Epstein case, one in the Maxwell case, prosecuted right here in the Southern District of New York. And on this point, we're in the Southern District of New York. We've got Jay Clayton, the new U.S. attorney, who is in this district. And we have this possibility of Ghislaine Maxwell testifying. So we kind of have some competing interests here, maybe, okay? If we unseal the grand jury transcripts and there's something in there that is useful, then Trump needs Ghislaine Maxwell's testimony less. And he kind of needs it in a way. And I think that's why Todd Blanche went over there, is because they're probably floating something, dangling something that's got the White House's attention. So they're over there having a conversation about that. So if they are able to bundle that up, right, put a lid on that or whatever is going on with that, or just show it's irrelevant even, right, to say that Maxwell is making something up. We had an interview with her. Todd Blanche went over, got some information. She says, oh, Trump did this, Trump did that. He says, oh, really? He goes back and investigates it, says, there's nothing there, lady. And then Trump said, okay, thank you for the conversation. Thank you for the investigation. There's not going to be a pardon. There's not going to be a commutation. That's the end of the story. So then, if you don't need Maxwell because you've got that part of the investigation bundled up and lopped off, then you can go focus on the grand jury transcripts and dig into that, because that might mine something for you that you couldn't have gotten for Ghislaine Maxwell. And if you are thinking about both of those as tactics and avenues that you can go to discover information, as we would, then the next question would be about which do you prioritize and which matters more? So are you putting effort into this? And if you are, can we see it? Or are you putting effort into that? And if you are, can we see it? So here we've got the context now around this. And here's a finance guy going in here. So we're asking ourselves, does he really want this material? Does he want to get to it? Or is this just kind of token filing that is just being done to placate the public so we all shut up about it? And you make the judge the bad guy, by the way. This is a major strategy that happens in law everywhere. And attorneys do this everywhere. Sorry, attorneys, I'm blowing the lid on it. But they blame the judge. Oftentimes the judge is wrong, okay? And the judge, you can rightfully blame the judge. But there's other times when the attorney's like, well, I can't believe the judge did that. And the attorney like knew the judge was gonna do that, and it's just kind of blame the judge and pass the buck. Okay, I see it a lot. And actually we would get cases like that. People would come hire our firm. This lawyer said, my other lawyer said the judge. I'm like, fuck, gosh. All right, of course he did. So you know how that can go. People will tell you that all the place, even if you go get your oil changed. And you need a new Johnson rod in there. For what? Fix your rods, you know? All right. So we're asking ourselves, we're always looking at who is filing these and what is their true motivation if we can't find it on its face. But here's this. It says, this memo, as directed by the court, you told us to do this, addresses the specific facts and factors highlighted in the court's orders relevant to the particular grand jury materials that are at issue here, in order to ensure that, quote, transparency in this process not be at the expense of the government's obligation to protect the victims, right? There's rules about that. And the government also requests leave to file a supplemental submission. Okay, once the government and the court have received any filings from the victims or others referenced in the transcripts. And if there's 1,000 victims and there's a possibility that a good portion of those are in the grand jury transcripts or proceedings, then that might take some time. And so we might see this beefed up down the line. But here is what the Trump DOJ says from Jay Clayton. As the court recognized, the Second Circuit has held that, quote, there are certain special circumstances in which the release of grand jury records is appropriate, and even outside the boundaries of the rules, which say that you cannot give these records out no matter what. Ultra secret. Saying there was this case called, this judge called C.J. Friendly said something like, well, there are certain special circumstances in which release of grand jury records is appropriate, even outside the boundaries of the rules. The Second Circuit enumerated a list of non-exhaustive factors for trial courts to consider when deciding these motions. Now, they gave us these factors, these indicia, these little check boxes you got to go through and analyze and measure them, put them on a little scale, balance the scale out, see where does it go. Does it favor disclosure or does it favor continual seal? The identity of the party seeking disclosure, who wants it? Well, it's the DOJ. That's a pretty big one. The DOJ wants it on behalf of the American people, okay? President Trump directed his attorney general to go do it. So it's big. That's like, there's a lot of weight to that factor, so you should unseal it. Whether the defendant to the grand jury proceeding or the government opposes the disclosure, no, they don't. So we can put some check boxes over here. We'll just tally that up. So we got 2 over here. And over here is going to be the seal side, so on the right side. Grand jury proceeding, does the government oppose it? No. Does Maxwell oppose it? We haven't seen anything yet. Number 3, why disclosure is being sought in the particular case? And that's a great question, right? So maybe you want to put that one in the middle. We would say we have a right to transparency. We've got questions about the performance of our judges and prosecutors and FBI agents and all the people who were responsible for this investigation, which seemingly was bizarre. In fact, it's not even seemingly, it's bizarre. He got a non-prosecution agreement that was like a blanket umbrella for everything until it wasn't. And he was allowed to operate hanging out with the most powerful people in the world for decades. So disclosure is for accountability, right? It's to make sure that there is actually justice, to make sure that the system is not completely corrupted and broken, covering up a global PDF file ring. So that's a pretty big why. Now, on the other hand, they would just say, well, it's for your prurient interests. You're just interested in sex and disgusting behavior and all these different things, which obviously we're not. We actually want to stop that stuff from happening, which is why we're so interested in it. But they might just say, it's, you know, it's just tabloid material. It's just salacious. And there's nothing really there that is legitimate for the public to have, which is maybe what they'll say. But we got another factor for what specific information is being sought. So we want everything, the entire files. And that's a big ask generally. Well, okay, so it's not narrowly focused. No, we want everything. How long ago the grand jury proceedings took place, which was not that long ago, actually. You know, it was, so if we're putting these out, we got 1, so we'll put number 2, we'll put in the middle, or that's a 3. What specific information is being sought? That's a lot, so I would say that I'm going to put that in the negative camp. How long ago did they take place? And we'll put that kind of in the middle camp because they're not that old, but Epstein's dead. The current status of the principals of the grand jury proceedings and their families. Okay, we don't know about that, so that's also kind of in the middle, I'd say. We don't really know, go either way. The extent to which the desired material, either permissibly or impermissibly, has been previously made public. And we don't know. We don't know what's in it, right? So we don't know what they've got that we don't have. I presume it's a lot. So if it is already made public, then you would not get it because you already got it. And so since it's not public already, I'm going to put that in our favor. The extent of disclosure, the extent to which the desired material either has been previously made public and whether witnesses to the grand jury proceedings who might be affected are still alive. And that does not go for us, right? There's probably a ton of witnesses who are still alive because these cases are pretty fresh. The additional need for maintaining secrecy in the particular case in question. And as far as we know, there's really no other reason for there to be secrets, unless it's something that's pretty problematic, like our intelligence agencies are behind it, or Mossad or foreign intelligence agencies were colluding in this operation. Yeah, that would be a pretty big problem. So you might say national security or something, and that would weigh against you. So, it's not, I think I'm obviously biased and arguing in favor of disclosures, but I can easily see the judge just saying, oh, it's just a bunch of live streamers who care about this. No one cares, so just leave it alone, But the DOJ continues. They say, all right, well, those are the factors you want us to analyze, so we'll do it. Says here, there's also currently a circuit split in the courts of appeals, writing, in light of this split, when the government sought to get similar relief to unseal grand jury transcripts back in the Southern District of Florida, from 2005 and 7, the Honorable Judge Rosenberg, who is bound by the 11th Circuit rule barring extra rule disclosures, denied that motion. And that's interesting. See, we don't know exactly what happened back then in 2005 and 7. They said that they were preparing a 65 count indictment. Acosta was at the time. They were going to obliterate Jeffrey Epstein back then. Then Acosta got pressure from somebody. He says, some FBI agent says that Acosta said that it was intelligence, that Epstein was intelligence. But they had him back then. And this case never went to a grand jury based on these federal charges. So they sought to go get those things, and the judge said no. Now, he's dead. We should absolutely get those. And we don't even have a case, though. Okay, that case never got filed. That indictment, they were investigating it, preparing it, probably ready to drop it, and then they got cut. And then he got charged at the state level with state crimes that were just by agreement, and he didn't have an indictment at all. So the federal case never got charged. There's no case number. There's no notices of appearance. There's no discovery motions, nothing, because they settled it pre-indictment for this dude who's like heinous. Okay, so you would never get that. And in that settlement, they also gave him a non-prosecution agreement for 4 co-conspirators that I thought, as written, was extremely broad and covered Ghislaine Maxwell. She doesn't, and the Supreme Court probably won't either. But that is very important to know, that there's a whole other bundle of materials back from 05 and 07, and he's bound by the 11th Circuit rule saying, I can't give it to you. So we got to get this resolved. What is the rule? Is there a special exception, or are there only the rules about disclosure? So on July 22nd, the court directed Trump's DOJ to file a memo of law addressing with specificity these and other factors the government views as germane to its application. The court also directed the government to state whether, before filing the instant motion, counsel for the government reviewed the grand jury transcripts, like did you read anything? Is there anything even useful in there? And whether the government provided notice to the victims of the motion to unseal. Now, and to submit, they want indices of the grand jury materials, a brief summary, the number of pages and dates, a complete set of the grand jury transcripts, complete proposed redacted set of Epstein and Maxwell grand jury transcripts, and a description of any other Epstein and Maxwell grand jury materials, including exhibits. It's like, great, just put that in a Dropbox for us. Just put the link on there. Google Drive, I'll host it. I got extra space, no problem. Just let me know. I'll help. Happy to help. So it would be pretty easy to just share all of that. We'll see what the judge does. Now, here is what the DOJ says in response to the factors. Now, the court directed the government to address the factors. What follows is a discussion of each of the factors, which are designed to assist the court. You asked to have some help creating some careful judgment about your decisions, Judge, and so we're going to help you figure that out and balance the interests around public disclosure and public interest. Now, the first factor is about the identity of the party seeking disclosure. So who is ultimately the one requesting it? The DOJ. The first factor considers which party is seeking disclosure. the identity. It carries great weight. Here, it's the government. They want grand jury transcripts, and it's consistent with increasing calls for additional disclosures, okay? It's the public. And here's this press release. So it's not just the public, it's also Congress, which is unfortunately a little bit more powerful than the people. But Chairman Comer issued a subpoena for Maxwell and then said she's not going to get immunity. So that subpoena is now basically trashed. I mean, she'll show up, but she'll just invoke the fifth repeatedly. The government's position serves as a preliminary indication that the need for secrecy is not especially strong. Like, the government's not worried about it, so we can unseal it, even if it's not dispositive. Now, government support cannot confer disclosure. Like, the government can't say, well, we approve it, so judge, do it. But not objecting is a big deal. The second factor asks whether the defendant or the government opposes public disclosure. This was a big question. What's Gouveia going to say? Because if you're Gouveia, if you're her defense attorneys, you say she's probably got a strong interest in keeping herself as the sole source of information. Okay, so she should object to these disclosures, because if these disclosures are made public, it means we need less of her. Now, we'll see. A defendant's opposition to public disclosure is also not dispositive, and we haven't heard from her. Yeah. Maxwell has indicated that she expects to craft a response and set out her position to the court. Okay, so we'll see. Now, Epstein is dead, probably. So he can't have a position, they say. Except being 6 feet under, maybe. Where is he? Do anyone know? The third factor considers why disclosure is being sought here. The Second Circuit said, well, it's entirely conceivable that in some situations, historical or public interest alone could justify the release. It's possible. As described above in the underlying motions, there is undoubtedly a clearly expressed interest from the public, all right, and Ghislaine Maxwell's crimes. Beyond that, there is abundant public interest in the investigative work conducted by the DOJ into those crimes. And so, as noted, we have not received any outreach from any of Epstein's surviving family, right? So they haven't contacted us. Nobody's saying, don't go after this. Everything seems like it's pretty quiet out there. Now, attention given to Epstein and Maxwell has recently intensified in the wake of the July 6 memo, the other J6 memo, announcing the conclusion of the review into Epstein and Maxwell. And yeah, it caused this whole thing to explode. That 2-page unsigned memo. The instant motions for unsealing are consistent with the fundamental purposes set forth in that memo, given the magnitude and the abhorrence of his crimes, to provide information to the public while remaining sensitive to protecting the rights of the victims. Now, fourth factor. The fourth factor asks what specific information they want disclosed. Here, the government wants the transcripts of the Epstein and Maxwell cases and exhibits as well, and all the filings as well. As stated in the motions, any public disclosure granted by the court would be subject to appropriate redactions of victim-related and other personal information. So, like, there's, transcripts, like, you want that to be everything. Like, we want all the boxes. And sometimes you call them the grand jury transcripts, but you're getting all of the evidence. So you want to be careful with those words and see what they're actually going to get us. Like, are they just going to release the only document that was the transcribed document? That's it. No exhibits, nothing else? Probably. Here, how long ago the grand jury proceedings took place? Not that old. June and July in the Epstein case, and then June and July of 2020. So Epstein is in 2020. Epstein 19, Maxwell's 20. Here, the passage of time has not dulled the public's interest in these cases. No, it has not. If historical interest in a case has persisted over a number of years, that's a pretty important indicator that we're not letting it go. Now, the current status of the principals and their families, the sixth factor. What is the current status of everybody who is involved in the Maxwell-Epstein grand juries? The passage of time brings about the death. That brings about the death of others. Should matter, but it might create vulnerabilities. And so in this case, the grand jury testimony was offered specifically in connection with charges against Epstein and Maxwell. Epstein's dead. No family member has even come to the government saying they have any interest in these motions at all. One of Epstein's family members previously filed a request for materials pursuant to FOIA, But we responded, no litigation happened. Maxwell currently is incarcerated, and no family member has approached the government indicating an interest in any of these motions. So, like, Max and Robert Maxwell, her father, had a bunch of kids. Several of them died, some of them in weird situations. But a brother might say, well, Maxwell talked about me and about how I also got abused by our father or something. And so if that comes out, then that would be devastating to me and my reputation. And I had nothing to do with this. So I'm an innocent party. And so I'm just going to object because there's going to be some spillover. We'll see. But nobody's said anything thus far. Sounds pretty quiet. The extent to which the desired material, either permissibly or impermissibly, has already been made public, the government is not aware of the relevant grand jury transcripts ever being impermissibly leaked. Certain aspects and subject matters of the transcript became public during the Maxwell trial, which we covered at length, to the extent that any of the desired material was disclosed to Maxwell as a result of the disclosure obligations. It was disclosed pursuant to a protective order. Now, many of the victims whose accounts related to Epstein and Maxwell that were subject also testified at trial, and it was consistent with the accounts of FBI agents and detectives from New York PD. And it was factual. A lot of that was used in civil litigation too. Now, the government is providing under seal a list of witnesses whose accounts were conveyed in the grand jury proceedings. I wonder who is on that list. Noting which witnesses testified at trial too. The eighth factor is whether witnesses to the grand jury proceedings are still alive. Here, there was one witness, an FBI agent, during the Epstein grand jury proceedings. One guy. There were two witnesses, the same FBI agent from the Epstein grand jury proceedings and a detective with the New York Police Department task force with child exploitation during the grand jury proceedings. Both witnesses are still alive. So one person worked on both cases plus another one. The FBI agent continues to be an agent with the FBI, still available, and the detective continues to be a detective as well as a task force officer. And so, consistent with all the rules, we are including statements of others who are still alive. In the sealed submission accompanying this filing, we'll know which victims are still alive. And finally, the final factor says the additional need for maintaining secrecy. Is this like a national security catch-all somewhere? In addition to the typical reasons for grand jury secrecy, the grand jury transcripts contain victim-related and other personal identifying info about third parties, which might be involved but were not charged, to which the government is sensitive, and which is why we want to redact the transcripts before releasing them. Now, the court directed the government to state whether, so if you think there's going to be names in there, like any names at all, there are not going to be a single name in there that we don't already know. The court directed the government to state whether, before filing the instant motion, counsel for the government reviewed the Maxwell grand jury transcripts. Before filing this, we did review the transcripts. The government has provided notice to all but one of the victims who are referenced. The government has attempted to contact the remaining victim but can't find her. In addition, the government is in the process of providing notice to others. And so the court directed us to submit a bunch of things. Indices of the materials, number of pages and more. The complete set of all the transcripts. Complete proposed redacted set of the grand jury transcripts. A description of any other materials, right? So that's kind of what we're talking about. Including but not limited to exhibits. So when they're referencing transcripts, it's the transcript. That's it. As to the final category, the government provides a description of all the underlying materials presented to the grand jury, as well as copies of and proposed redactions to certain materials. So we're submitting all of these ex parte, not showing the other side, and giving it to you under seal. So the public's not going to see it, the other side's not going to see it, and you get to do what you want with it. The government underscores that it takes very seriously its obligation to protect victims and believes the redactions not only are appropriate, but are necessary to protect those rights. All right, so that came out from Jay Clayton, the newest U.S. attorney over there in the Southern District of New York, in a 10-pager, bunch of supplements, bunch of materials got transferred over. We'll see where it goes. Now, Democrats are doing something sneaky as well. Chuck Schumer is going wild over on X. He's having a tough time being on the losing end of everything, including his entire life. But he posted this. He said, release the files, the Epstein files. Like, where were you 7 months ago, Chuck? We know. So they're trying something interesting. They got this new Senate rule, apparently. They're going to try to force the release of the files with this little-known rule. And so he is referring us over to this New York Times article where they said that they are now moving to compel the Trump administration to release this material. It's compelling them. Chuck Schumer and all 7 Democrats sent a letter to the Justice Department requesting that it turn over files. Under a section of federal law, commonly referred to in the Senate as the Rule of 5, government agencies are required to provide relevant information if any 5 members of that committee, which is the chamber's chief oversight panel, requests it. Under a section of federal law? Okay, let's see what that one says over here. An executive agency on request of the Committee on Government Operations of the House of Representatives or any 7 members thereof on request of the Committee of Governmental Affairs or any 5 members here shall submit any information requested of it relating to any matter to the committee. So that's the rule. 5 U.S. Code, Section 2954. If 5 Democrat goons get together, they can invoke this law and force Trump to give materials over to them, according to them. So the New York Times says, the provision became law in 1928, sets a 7-member rule for the House's Oversight Committee, effectively offers a way for members of the minority party to compel information out of the executive branch because they cannot issue congressional subpoenas. But it's been infrequently used. Yeah, and has not faced any significant tests in court because it's unconstitutional, raising questions about whether it can be enforced or not. Congress can force the president to give them documents when 5 minority members demand it? Where the hell is that in the Constitution? Is that anywhere that we've seen? That says the president that's a check and balance that is in our root Constitution or any of the following amendments? They just made it up, made it law? Get out of here. So still in invoking it, Democrats were trying to draw Senate Republicans into the debate, which is really all this is about. It's trying to create a wedge issue against the right. If the Trump administration were to ignore the request, there'd be a legal battle, and then John Thune would have to decide what's he going to do. Since Trump returned to the White House, Congress has ceded much of its oversight power, Republicans showing little willingness to hold hearings. Well, because they're on the same party. Weird New York Times reporter. But all right, so we got the story from them, and we know what's happening. We'll see if what Trump does in response to that. They're not going to give them anything as a result of this. So good try to Chuck Schumer. He'll just have to get used to losing for the foreseeable future. And we'll keep our eye on this one. So more updates in the Glenn and Epstein cases with this memo coming down. So now we'll wait. We'll see what the judges say. They'll continue to wait to get some updates on the victims. They got to wait to hear from Maxwell. Maxwell is right now, I would imagine, trying to figure out what her strategy is. If she objects, that's because I think she's trying to be the sole source of information. If she says, oh, no, it's, whatever, then she's got it all. And she can dangle whatever she wants. And if she knows that those are not coming out, then she might have a little bit more freedom and, free range to say what she wants to say without being cross-checked, without the public saying that's not what came out in the grand jury proceeding. So, and if the DOJ is not going to be forthcoming with us about releasing their files, because the DOJ could obviously do that. Like, they don't need the courts to give us records. The DOJ, the FBI, they've got a boatload of records, and a boatload of records don't have anything to do with victims or victims' rights or other witnesses, all sorts of information that they could just drop because the grand jury transcripts are a subset of the grand jury proceedings, and the grand jury proceedings are charges that are a subset of a much broader investigation that include uncharged possible charges. And there's a bunch of evidence and other things that you just cut out of it that never make it in to any of these proceedings. And so they've still got access to all of those materials. We'd like to see them, and it's not going away. So hopefully we get some good news from the judges and they open up these books in the name of transparency for America. All right, so good updates on that one, my friends. And now, let's see what else is cooking out there. Because we have a backdoor judge update. Oh yeah, you know how much we love backdoor Judge Dugan. And she is getting it. Backdoor Judge Dugan now getting ripped in a DOJ response. You remember this case. This was the judge who tried to escape that illegal alien out her back door. Said, come use my back door, no problem at all. And there were victims in the courtroom, and she went out, interfered with ICE agents who were in the hallway to prevent them from actually conducting the arrest of this illegal, snuck him out the back door, and then had the audacity to come around and say, I'm a judge, I'm allowed to do whatever I want. It's in my court. And so if I shot somebody in the head, big deal, because I decided that that was the appropriate sentence for them. And so there's nothing you can do about it because I'm a judge. Now, more or less, that was her argument, and she submitted a motion to dismiss her entire case. We read through some of it here, but she now then got lost another filing, which was to say that the case had a basis from the lower level magistrate judge. And so we've had the report that came down from the magistrate judge, and Hannah C. Dugan objected to that the charges were valid, right? So basically Dugan was saying the charges are not valid, my case should be dismissed. The judge said, actually the charges are valid, your case is going to go on. Then she says, I object to your conclusion there. Now Pam is responding to that objected conclusion. And we'll go through them because Bondi laid it out. Now, this was the original filing. This was Dugan's objections to the judge's recommendation. The lower level magistrate judge found that this was a valid case. There's probable cause here. You can actually prosecute this judge. She says, I object, and this should be dismissed. And in her filing, which was a 30-pager, she was explaining, I've got judicial immunity, okay? And even the Trump case, the Supreme Court case, said presidents have immunity. Now, we know it's a lot more nuanced than that. You hear a lot of the cable talking heads just say, well, presidential immunity means all presidents have immunity for everything. They have no idea what they're talking about. There's absolute immunity, there's presumptive immunity, and there is no immunity. The Supreme Court, there's a third bucket there. And now this judge is saying, I have that power too, because I want to be the president, who she thinks she is. Now, here is what Pam Bondi and the DOJ said in response to this one. Now, this is a nice substantive filing. We got 30 pages here in response to Dugan's motion to dismiss her case and to undo what the magistrate judge did. And this is being filed by this guy. His name is Richard Frawling, acting U.S. Attorney, Eastern District of Wisconsin. And he's been around a while, served as a supervisor, 20 years, criminal chief, been in private practice, went to Yale, right? So dude's been around a while, and he's now handling this case. So he knows what he's doing. Now, here's what he says. The United States of America, by Richard Frawling, that guy, hereby responds to Backdoor Judge Dugan's objections, saying the lower level judge recommended the case proceed. For the following reasons and those stated in the report, this court should overrule Dugan's objections and deny her motion to dismiss. Here's why. Dugan, this judge who tried to escape an illegal, faces a 2-count indictment alleging that on April 18, 2025, she attempted to unlawfully prevent the arrest of that illegal alien. And of course, they get pseudonyms and initials because they're the favored class in this country, who was wanted on federal immigration charges. They had a warrant for him. Now, more importantly, the indictment also alleges that Dugan, upon learning that federal agents planned to execute the arrest warrant in her courthouse, that she knowingly violated the law, concealing this illegal to prevent his discovery and his arrest, and also corruptly endeavored to influence, obstruct, and impede the arrest on a warrant and affirmatively assisted him in his escape. And those affirmative acts were numerous. In fact, they're listed right here. Confronting members of ICE and falsely telling them that they need a judicial warrant if they want to actually conduct an arrest. When they learned that there actually was a warrant, they then directed all of the task force members to leave the location of the arrest and go down to the chief judge's office so she can let the illegal use her back door. Addressing the Milwaukee Circuit Court criminal case off the record, the judge didn't even hear from the prosecutor in the case, didn't hear from the victims who were in the courtroom, and just granted this dude a continuance and said you could appear by Zoom because we don't want you to come down here and get arrested by ICE the next time. Also, directed the illegal and his lawyer to exit through a non-public jury door, her private back door, advising the counsel and the illegal that they could appear by Zoom for his next court date. So then Dugan moved to dismiss the indictment. She says, I've got judicial immunity and nothing you can do about me. And also, they're quoting this, vertical separation of powers, they're quoting that. Saying more particularly, she said that she's entitled to absolute immunity from prosecution because common law permits only 3 categories of crimes against judges, and none of them is charged here. And so since there's no exception to these rules, you can't charge me and my case has to go. Citing the 10th Amendment, she also argued that the federal government lacks authority to prosecute state court judges for official acts. Now, the government, Pam Bondi and Roy, the government explained that judges have immunity from civil lawsuit, but not federal criminal prosecution. And if judicial immunity applies at all, it only immunizes judicial acts, not illegal acts like using illegals out your back door. And that doesn't help Dugan because she acted outside her official role. The government also explained that the 10th Amendment provided no personal immunity and does not prevent the prosecution of state officials, including judges, for violating federal law. You think you're immune from that because you're above the law? Now, in a 37-page report, the lower-level judge, Magistrate Judge Joseph, thoroughly analyzed everybody's submissions. Joseph applied the proper standard of review, saying the indictment's allegations are presumed to be true and they should be viewed most favorably to the government. Now, after an exhaustive review of the history of judicial immunity, the judge went through this. She found no authority to bar this prosecution, and she rejected Judge Dugan's argument as unprecedented and unauthorized, an expansion of judicial immunity way outside the historical context, just making it up because it serves her. The magistrate judge also found that her reliance on the 10th Amendment and constitutional avoidance was also misplaced. Constitutional avoidance, she should avoid interfering with the executive branch conducting their lawful arrests. Dugan has now objected, essentially repeating the arguments that the magistrate judge already rejected. And so for the reasons set forth, because the judge's analysis was comprehensive and correct, this court should overrule Judge Backdoor Dugan and deny her motion. Here's why. In her objection, the judge asserts that she is beyond the reach of the law that apply to normal peasants like us who obstruct federal arrest because, unlike them, she's entitled to immunity for her official acts. You try to insurrect an ICE officer, see what happens to you. But she's a judge, so she can do it. In particular, Dugan claims that the judge's report and recommendations clashes with first principles. Oh, gosh. Tech bro lawyers, and a doctrine of judicial immunity that dates back 4 centuries, as well as the Supreme Court's recent decision in Trump versus United States, which granted Trump that presidential immunity for official acts. Dugan is wrong about the application and the scope of immunity. In the simplest of terms, to quote the judge, judges are not immune from criminal prosecution for acts wholly outside of their official roles as judges. That obviously makes sense. And even when a judge's actions are related to official duties, there's no immunity for conduct that violates criminal law. Generally, a judge is immune from a suit for money damages, quoting the law. For judicial acts, the protection of judges from civil liability arose because it was in the public interest to have judges who were at liberty to exercise their independent judgment about the merits of a case without fear that they're going to be sued for their ruling. Every time, right, you're guilty of this traffic ticket. See you in court, judge. You're wrong. And suing you, lawsuit's valid, and so you sue the judge for some, traffic ticket, which might be nice. But to the contrary, you probably get a lot less traffic tickets. To the contrary, the Supreme Court long has recognized that a judge is not absolutely immune from criminal liability just because you say you did it as a judge. What? In fact, the Supreme Court has made clear that the judicially fashioned doctrine of official immunity does not reach so far as to immunize criminal conduct that's proscribed by an act of Congress. The court has never suggested that the policy considerations which compel civil immunity for judges in certain cases should ever be extended to criminal law. And so given the pronouncements from the Supreme Court, the Bondi DOJ says, it is no surprise that many cases have been prosecuted against judges who violate these criminal statutes. Happens a lot. We do it all the time. And citing some of those. Now, Dugan attempts to explain away the absence of cases supporting her position. Where are all the other judges who did bad things and they're claiming immunity and they got away with it? Oh, they don't have any? She argues that judicial immunity from prosecution is so entrenched that it's always applied, okay? Well, I can't find any cases because no judge has ever been prosecuted before. Well, maybe no judge has never used her backdoor for illegals. Is so entrenched that it has always applied, and no extension was even needed. It's just so obvious. You don't even have to question it. Dugan's repetition of the same arguments that she made to the lower level judge demonstrate errors in her thinking. The judge exhaustively analyzed all the relevant authorities, examined cases, examined civil rights statutes. The judge considered Dugan and her related contention that 3 categories of crimes can only be pursued, and definitively rejected her. But here's why Dugan is so wrong, and this is a bizarre thing that she's done here. In her objections, Dugan is relying on this case. It's called Floyd versus Barker. You might say, oh, that sounds like like an American case. It's not. It's from 1607 in the Star Chamber in England. So why is she referencing foreign law, foreign legal cases? Well, it's because it's part of common law, and we adopted it. But is there nothing newer than 1607 on which you can hang your hat there, Judge? Kind of a stretch. However, as the judge recognized at the lower level, Floyd has no discernible effect on the question of judicial criminal immunity here. Back in Floyd, even if you say that's relevant, look at it. It involved an unusual collision between the courts of the Star Chamber and the common law courts. Lord Coke determined back then that a claim of conspiracy brought against the judge of the courts while trying a murder case wasn't appropriate. And Lord Coke said that it would slander to the slander of the justice of the king and the scandal of the king himself, and deliver continual recriminations because everybody would be mad. So accordingly, Floyd arose in an unusual legal context that has no parallel in modern American law. Weird. Certainly not in this case, involving in a federal prosecution of a judge for violating crimes outside the scope of her duties. In England, it's like these 2 different courts, they're like mad at each other, kind of fighting each other. And then they said, well, one court that's under the king can't attack another court that's under the king because it's like an attack on the king. And so the judges are immune. And so stop the infighting kind of a thing. And we don't even have that. That's not what we're even talking about. This is a federal criminal statute, Judge. To that end, the lower level judge only found 2 pertinent cases where the Supreme Court even invoked that old English case. But as the judge observed, those cases were only for civil cases. The judge accurately said that in the 154 years since this other case was decided, Dugan does not cite, and I have not found, cases where the Supreme Court invoked Floyd for criminal immunity, ever. And so her objections also fail there. Now, similarly, contrary to Dugan's assertion, the Supreme Court did not adopt judicial immunity in the context of this other case. The judge noted this too. Said, these are all weak support. The judge said, weak support for you, Dugan. In response, to the court's well-reasoned explanation, she then turns to modern Supreme Court decisions, but they don't support her either. She cites a bunch of these cases in this, but Dugan's objection cites only Trump. So it seems like the judge cited all these cases, but Dugan is just picking one. But the one case is clearly distinguishable. This was the case that Trump got immunity from the Supreme Court, writing, that decision held that the president has criminal immunity for official acts based on the presidency's unique position to the constitutional scheme. The president, in a president, not the office of the president. It is a sole singular person. And the unique risks to the effective functioning of the government if presidents were forced to constantly assess whether their decision-making while in office might one day prompt criminal inquiries. So if you apply Trump to judges, to the tens of thousands of people across the country who are in judicial roles, that is a warrantless and baseless extension. Now, Dugan is trying to do that. She thinks she is the president. She can overrule Trump's executive orders by using her backdoor, and you can't charge her for any of that. While Dugan says that Trump extended this to the presidency, it's already been granted to judges. That's why Trump got it, is because the judges had it first. Now, consistent with this analysis from the judge, judges have been prosecuted in dozens of cases for wide-ranging criminal conduct, including obstruction. Many of them, citing this one. Here's one. This one, 2017, 1975. Got 2014, 1993. 1984, another one. Happening here, 2019. 2018 over this one. 2009 over here. We got more criminal charges against judges right here. Dugan faults the magistrate judge for following and would have this court ignore the Supreme Court in modern practice. What she's trying to do is take that case and apply it to her, but it doesn't. She suggests that the Supreme Court statements in other cases should be disregarded as dicta or as strictly applying to violations of certain rules. But in other words, the law that she's referencing should not be taken for the proposition that judges are immune from criminal prosecution. These other laws have been on the books for years. No one's ever said that they're immune from criminal conduct anywhere. Now, as the lower level judge correctly noted, her argument is unprecedented. She says, if that's true, then Congress must clearly say that, saying it only has weak evidence that it even exists, that there's any immunity there. There are exceptions to the rule, but we haven't seen any strong showing that you have this right, Judge. The magistrate judge also correctly rejected Dugan's related assertion that immunity only goes to certain categories of crimes. Wholly unofficial acts, which would be also not immune in the presidential category, right? If Trump did something that was not a presidential act at all, outside the scope, he would not have had immunity for those acts. Deprivation of constitutional rights and actions related to their duties if they engaged in self-serving activity like fraud, okay? And that she doesn't qualify for that because her escaping the illegal out her back door was not fraudulent. She didn't make any money or anything like that. Now, she did get a sense of smug self-satisfaction that she was helping, I guess, illegal aliens who beat people and get charged with crimes in her courtroom, like stick it to the man, stick it to Trump or something. So I would say she doesn't need a monetary financial benefit. The fact that she's really enjoying herself in the process is enough. Only the third category merited discussion under the facts, and the magistrate judge agreed with the government that there's no authority limiting so-called judicial act prosecutions to only those crimes that have a self-serving motive. To quote the judge, but whether a judge seeks his own self-gratification, as she did, or self-enrichment is not the distinguishing feature for immunity. What matters is whether the judge, even in performing their duties, is accused of committing a crime. Now, the lower judge also explained that Dugan's categories were also inconsistent with other cases like this one and this one. She says the judges were validly convicted in those cases, but those were unofficial acts, in her view, and they were only tangentially related to judicial acts. But there's no need to draw these lines. No authority supports that at all. Dugan's assumption of immunity wrongly inverts the analysis on the motion to dismiss. Even in her view, criminal prosecutions of state judges are undisputably permitted in certain circumstances. However, this does not imply the creation of other categories. She's just simply attempting to explain away the historical prosecution of judges in a gerrymandered way, saying, well, their case was official and their case was fraud, but mine's not. Quite simply, there's no rules about that. The Supreme Court has never retreated from its observation that judicial immunity does not apply to criminal cases. So she's having this battle with herself to try to fake like there's a line here, but there's not. There is no, immunity. Like, we don't have the same three-bucket framework that we have on presidential immunity for judges. She's trying to make believe that there is. It hasn't happened yet. Maybe they'll come up with that. Maybe this case will go up to the Supreme Court and they'll decide that, but they haven't. As such, whether something is a judicial act has never been the focus. Now we're talking about that in the context of Trump, but rather the dividing line is whether the conduct fits the elements of the criminal statute. You can't have the Trump rule. At minimum, Dugan's objection would not provide a sound reason to dismiss the indictment now anyways. Accepting her claim about the nature of the prosecution would require fact-checking, and we can't do that right now in the middle of a motion to dismiss. Her proposal would also create a situation in which the same conduct would constitute a judicial act for civil immunity purposes, but not a judicial act for criminal immunity purposes. That's interesting, right? So how do you split that one? For example, suppose a judge makes a favorable decision and gets some money. Well, that's a judicial act, and there would be civil, but not criminal immunity. And so the rules don't even make sense in practice. Now, moreover, even assuming that we went through and did an analysis on this, there's no basis for a dismissal of her charges. As the government previously explained, because judicial immunity does not apply, this court doesn't even need to inquire into whether the acts are judicial or non-judicial. And the magistrate judge did that, discussing judicial and official acts only to emphasize their irrelevancy. They don't matter. This is not the Trump case. Or the pivotal issue of whether judicial immunity from prosecution exists at all. It does not, so this court should likewise decline such an inquiry. However, if you're going to go into this, it wouldn't even help Dugin anyways. In the indictment, she went well beyond her official role. She endeavored to prevent law enforcement officers from executing a valid arrest. So we shouldn't even be talking about valid arrest, judicial acts or official, non-official at all. That's not the rule. But we will, because she's going to lose even if we apply her rules. Central to Dugin's arguments is the misconception that she's charged for committing official acts as a state judge, and that she was doing her job and nothing more. She was just being very helpful. She had to process cases that were coming through. She had to get through a very busy docket that morning, and she had a perfectly reasonable exit right here. So she was just being a courteous judge and helping people get through get through the docket more quickly. Kind of the same kind of fake compliance that we see from Obama when he's like, this coup that we're doing has to be by the book. Just make sure you don't do anything that anyone can catch us for. I'm like, yes, sir, we're on it. The government addressed this in its prior response, refuting Dugin's factual claims that went well beyond the four corners of the indictment, and they're even contradicted from the materials in the discovery. She asserted in her filings, this judge, that the agents disrupted active proceedings. No, they didn't. They were sitting outside. You disrupted them. That they disrupted her courtroom, and that they decided how they wanted Dugin to control her courtroom and the people near it. Dugin continues to make these unsupported claims. Now, as the government has indicated, none of this is true, and nothing in the indictment or the anticipated evidence at trial supports it. Instead, all events arose from Dugin, her unilateral, non-judicial, and unofficial actions outside the role of a judge, which again isn't the standard, but she was still acting like a criminal. The evidence will show that her actions included pausing an unrelated case, leaving her courtroom, disrupting proceedings in a colleague's courtroom, clearing agents out of the public hallway, quickly returning to the courtroom, directing the illegal's attorney to take your client out and come back and get a date, and then go through the jury door, her back door, down the stairs, stating that she would, quote, take the heat for her actions. And then she physically escorted the illegal and his attorney into a non-public hallway with access to a stairwell that led to a courthouse exit. And that was all judicial official business, too. Endeavoring to obstruct an unrelated proceeding before a different sovereign, a public space where federal agents had every right to enforce federal law, is not a function normally performed by a state judge, all right? Not normally how that works. Now, in her objections, she claims that the judge agrees that every act this indictment names is part of a judge's job. And going even further, she says that allegations are official acts and that you can't prosecute me for this. Now, she misstates what the lower level judge said, and the lower level judge actually refutes rather than supports her official acts argument. At the outset of evaluating the motion, the judge relied on the truth of the allegations in the indictment to resolve factual disputes, but she nonetheless was seizing on a sentence and paraphrasing something else the judge did. Very dishonest. Now, so the magistrate judge did not endorse Dugin's official act arguments, either factually or legally. Rather, after tracing the history of immunity, the judge answered a question, saying, applying the principles above, does judicial immunity shield Dugin from prosecution because the indictment alleges she violated federal criminal law while performing judicial duties? The answer is no. No immunity. The judge said, the indictment here says that Dugin acted corruptly. And as the lower courts found, Joseph, to the extent immunity exists in the criminal context, it does not shield against corruption. In my view, this is consistent with the cases where judges were prosecuted for performing official acts with bribery and other things. But although the lower level judge allowed that some of the allegations describe the conduct, yes, some of it is part of a judge's, a judge does have a courtroom, and they are in a courtroom, and they are wearing a robe and stuff like that. So some of it, yeah. But it wasn't like she was doing something like opining on the fly. Dugan is not immune simply because she encountered federal agents. She was not doing her job. She was adding extraneous activities to the legitimate actions of a judge. Now, as she has acknowledged, she was elected to adjudicate the disputes and administer the laws of Wisconsin, but her actions were obstructing the law. And they could not have been in furtherance of judicial authority because she says she has to follow the laws of Wisconsin. And those include following the laws of the federal government. And so if she's working against the federal government, she's in violation of the law. Dugan nonetheless appears to equate the authority of the federal government to that of a duly elected Wisconsin state judge. Both by law and Dugan's own reckoning, she cannot point to any basis empowering her to involve herself with federal agents who are enforcing federal law outside of Dugan's courtroom. On April 18th, federal agents were not, despite Dugan's mischaracterization, acting in a manner they preferred. They were doing their job, independent of and related to Dugan's job. They took steps not to affect Dugan's docket. It was Dugan's decision. She stepped outside of her courtroom. She obstructed federal agents, not by musing about the federal arrest warrant that they were executing, but by taking affirmative actions that went well beyond her state judicial role to prevent the arrest on the warrant, and the lower level judge was right. Dugan is wrong to claim that her actions alleged in the indictment were those of a duly elected judge. Nothing in the laws or anything she cites protects her. She also says that Judge Joseph misunderstands the Kids for Cash case, but she's wrong on that. Like judges in the Wallace case, Dugan may have used some judicial acts or tools, like wearing her robe when she was directing agents under this veil of authority, falsely telling them they needed a judicial warrant, adjourning the case off the record after initially telling the client to get out, directing the litigant to use a non-public door. All of those things are tools, just like the other judges in the Cash for Kids case got. Dugan also objected to the recommendation based on a lack of limiting principle, but her argument proves too much. The criminal law and the proper functioning of the entire justice system requires law enforcement officers and undercover agents to do their jobs. Under Dugan's framework, where there is complete judicial immunity from criminal law, the rest of the operatives would they would be the ones subject to criminal charges for doing their jobs. And Dugan overlooks the limiting principle that the crimes charged in the indictment have elements defined by Congress, and we got to prove our case. And now, the judge saw this, saying that Dugan is charged with knowingly concealing this person. And the indictment does not charge her with an inconvenience, right? It's a crime. You got charged with it. You can present your defense in court. Now, the magistrate judge also rejected Dugan's argument that the 10th Amendment bars this prosecution. She said, you can't do this, we got a separation of powers, but there's no error here in the judge's analysis. Dugan's argument was a wide-ranging discussion of federalism. She talked about the Dormant Commerce Clause, Second Amendment rights, general police power, Indian child welfare, all these things. It's like, when you argue public policy, they teach you this in law school. It's like, if your argument is, well, it's against public policy, that's a losing argument. It should be like your fifth argument. You should have a bunch of other ones first. Well, the Constitution says this. Then federal law says this. Then state law says this. Then you've got these other ordinances that say this. Then public policy favors what you want done. Okay, it's after all of that. So when you go down to something like this, right? And we're watching the DOJ just go through and kind of check those out. Now we're at basically the public policy argument. Dugan's objections do not explain why the 10th Amendment would be so categorical as to protect judges against federal prosecution. What is that? As to the question of federal authority, the immigration enforcement that Dugan tried to obstruct was lawful. It was in a public space, wholly within the jurisdiction of the federal government. They had a right to do what they wanted to do to conduct that arrest. Dugan's argument is also difficult to square with the Supremacy Clause. How is a judge superior to the federal government? That's interesting. Dugan complains that these weren't corrupt and that this is misplaced because she didn't get any benefit. But she cites no case suggesting that a court may rely on this doctrine, like constitutional avoidance, to get around a judge being corrupt. Well, if you indict that judge, it's going to be like a bad thing for society, kind of, because people will have a loss of faith in the judge and the judiciary. So we should just grant them immunity? is the argument. She appears simply to import her own amorphous and flawed conception of immunity into this, and corruptly is not eliminated by constitutional avoidance. And so, in conclusion, Richard Froling writes this: Dugan's objections restate the same arguments she made already and lost at the lower level below. And the court, so therefore, should overrule Dugan's objections and deny her motion to dismiss. So we'll see what happens on that. I think this will be granted. In other words, the case will not be dismissed, and it will proceed forward. But what is happening is Dugan is trying to anchor in her appellate arguments, and she may take this up to the Supreme Court and say, well, you gave Trump these 3 buckets, so give me the 3 buckets, and let us have the same conversation about what is official, what is not. And then you could go through all of the different factors and say, well, these factors are in favor of you were doing something official, and so you have immunity. Therefore, you cannot be prosecuted. That's the whole point of immunity. It's to prevent this from going forward. She has the right to a trial, obviously. She can just go and have the trial. Say, look, she can make her official acts argument at the trial. But she doesn't want to get there because she knows not going to work out so well. People aren't going to like, jurors are not going to like a judge sitting up there and saying, I have immunity for committing crimes, but you don't. And they get a vote on that? You will see. So she may take this up to the Supreme Court to try to get some judicial immunity. I doubt the Supreme Court gets it to her because a judge is not the president. They operate an entirely different function. Even though they try to act like little dictators, they're not. All right, and so, my friends, that's the Dugan update. Now, let's talk about censorship in Europe, and then we'll hear from you. What a beautiful day it is. I hope your week is amazing. Happy Wednesday. We've got this story here. The Europeans are trying to censor us. We knew it was happening, but now we've got even more information because Jim Jordan just published these 2 X threads that he's calling the UK Censorship Files, Part 1 and Part 2. And we've seen a lot of this happening, and a lot of it occurred in the last administration, I would say even in conjunction with the last administration, because they were all on the same team. They don't like people challenging anything. Just do what they say, believe what they believe, and you're going to be okay with them. But if you have any opposite ideas, you're in trouble. And they'll cancel you right off the internet. We suffered a lot of that here after January 6th. Now, the UK apparently is also going after Rumble. The UK regulators are threatening American companies with censorship, says Representative Jim Jordan, writing, "We will be monitoring Rumble's position carefully," is part of the language. This came out in an email to somebody at rumble.com from somebody at ofcom.org.uk. Hey, dear Rumble, free speech people, we note your position that you do not consider Rumble to be in scope of the act and that you don't have a number of people in the target market. We have not assessed or reached any decision, and we're going to decide. Now, we will be monitoring Rumble's position carefully, and we will be in touch should we become aware of anything that contradicts this position. And we would strongly encourage you to take the steps required by the Act to protect UK users from content that is illegal and might potentially harm our children. I would like to highlight an upcoming event, Online Safety of Children. And then they just censor people who they call alt-right. For more than a year, says Jim Jordan, the Judiciary GOP has been warning that the UK and European tech regulators are trying to censor US speech. And here was the one letter we saw back on August 15th from Congress to Mr. Theory Brenton. That was only the tip of the iceberg, though. Beginning in February, we subpoenaed 9 tech companies for their communications with foreign censors around the world. Now when foreign censors pressure companies, the GOP will know on the judiciary. Subpoenaed documents produced to the committee offer even more evidence this is happening. The Online Safety Act is the UK's online censorship law. Our friends in England. Online censorship? What are you doing over there? They must censor disinfo, misinfo, and hate speech. Wild. Now, Ofcom, and first of all, we had all of our disinfo and misinfo was coming from the CIA and the FBI and the DOJ and the White House and Hillary Clinton's campaign. So are they going to get censored too? Now Ofcom, the UK's media regulator, is targeting companies including Rumble Video and even Reddit. Wow. New non-public emails obtained by the committee reveal Ofcom's subtle regulatory threats to Rumble. Even though the UK is not a target market. Ofcom, would you like to meet again? Rumble says, no, leave us alone. We have very few UK users. We're not even targeting the UK market. Are you sure you don't want to meet? Yes, we're sure. They said, wrong choice. Wrong choice, bucko. That was on Thursday, May 8th. Let's see what these emails look like. Yeah, so here we go. Hey, dear so-and-so from Ofcom, UK censor dictators. Hey, dear Rumble, we're contacting you because we're going to want to censor you. We're still interested in learning more about how you protect users from harm. Get out of here. The government is sending private companies from the UK. UK government sending private companies in the US, in Canada. What are you doing to protect your users from harm? What kind of harm? Would you be available to meet with us on May 19th onwards, any day for 1 hour? We view a supervisory relationship between Ofcom and a service as the most effective way to review and assess compliance with its safety and governance duties. Get out of here. Alternatively, we retain the right to legally request information. Retain it. So Rumble responded and said, hey, dear jerkhead, thank you for your follow-up email. Rumble has not finally determined whether the Online Safety Act applies to us, but we are inclined at this point to think that it does not. We do not have a significant number of online users in the UK, nor is the UK a, quote, target market for us under your stupid rules. And while Rumble is capable of being accessed by UK users, we do not believe that there is a material risk of significant harm to UK users of Rumble. As such, we do not believe that a call is necessary at this time. So, no, we don't want to talk to you. Stop texting me, you psycho. They respond, oh, okay. Well, thank you for your email. We note your position that you do not consider Rumble to be in our market. Now, we have not reached any conclusions, but we're going to monitor Rumble's position carefully. And we would strongly encourage Rumble to take the steps required by the Act to protect internet users from content that is illegal. Get bent. That's right, UK authorities want to supervise, says Jim Jordan, a non-UK tech company that doesn't even exist there. So why is a UK regulator harassing US companies? Rumble held the line for now, saying, hey guys, like Congress could help out with this. Can Congress do something to help? Rumble held the line for now, arguing it's not within the scope, but then they responded. Now, Rumble's not the only company that's getting hit with this stuff. New documents produced to the committee under subpoena also show that they began the, quote, supervision of Reddit, too. In Reddit's case, Ofcom said that the supervisory relationship would help embed British standards on social media, like on topics like hate speech, about the trans, which I don't know if you can say that over there in the UK. Jim Jordan says, in many cases, those British standards run counter to fundamental American free speech principles. He even singled out Reddit, saying that the Redditors, they talk too much garbage over there, not in alignment with British lawmakers. So it's no surprise British officials suddenly hate free speech, and Congress is now exposing it. Now, here is part two. As the UK becomes increasingly frustrated by a system of weaponized government against them, UK authorities wanted big tech to censor discussions about immigration and narratives about the police and a two-tier system, okay? It's about information that is harmful to the powers. That's all it is. It's straight out of 1984 and V for Vendetta. And we don't know what England is doing over there. But here is what this letter said. Hi, redacted. Thank you for your help in relation to Southport. I am sure you will not be surprised at the significant volumes of anti-immigrant content directed at Muslim and Jewish communities, as well as concerning narratives about the police and a two-tier system that we're seeing across the online environment. Yeah, and if Muslims and Jews want to kill each other on the internet, they're free to do it, just like everybody else is. And if we want to talk about unfettered illegal immigration and how it's a gigantic problem for the whole planet, we're tired of being invaded by the third world, then we're allowed to talk about that, unless you're in England. Now, as we would expect, this is manifesting in different ways, and we're sharing some examples here. Yeah. Some people talking about protests, warning that there might be blades being hidden in stickers. But okay, but it's disinfo, right? So this example is saying that somebody is saying that there's going to be a problem with this protest, so don't go to this protest. These are not specific to TikTok. Now, given the risk of misleading and false claims, we're keen to understand, A, what content you are seeing across your platform, and B, any measures you've taken in response. Please let us know and get back to us. From these censors in the UK. No thanks, we're good. We got other work to do. Jim Jordan also said, UK citizens are getting fed up with this. Mean tweets can land you in prison for like misgendering somebody on the internet. Britons were rightly concerned about a justice system that treated government critics more harshly than violent criminals. Right of center leaders were also justified in criticizing their two tiers. We got that over here. Now, what did they do? New documents produced to the committee show that they tried to censor people who said it's a two-tier system of justice. In an email to Big Tech, one of the UK's tech regulators, known as DSIT, told platforms to monitor narratives. And that's what they're doing, straight out of 1984. But the UK government didn't stop there. They also tried to censor public debate about immigration and wrote this. We wanted to draw your trust and safety team's attention to this piece of content. It shows scrolling of a Freedom of Information request posted on this webpage here and refers to asylum seekers as, quote, undocumented fighting age males. Wow, you can't say that in England? If you say your country's being invaded by undocumented fighting age males, which is a true fact, I guess that's illegal. Probably because the invaders want you to be invaded. And the people who would prevent the invasion are co-conspirators with the invaders. Just to flag the context, hotels for asylum seekers have already been targeted, blah, blah, blah. Please could this be assessed by the trust and safety team? There is a definite sense of urgency from here. We really appreciate we lived through this crap, man, with Twitter and after January 6th, all that. It's sick. The censors are the worst. UK authorities sent the post to the platforms as an example of concerning content. Yeah. This guy. It looks like Islamabad, but it's Manchester. That's Manchester? That's crazy. It does look like Islamabad. I would have never guessed that. Look at all those flags. Interesting. Yeah, so the question, of course, is why can't you talk about that in England if you're a free people, if you're a free country? Are the English free, or are they subjugated to the Palestinians who may say that you can't talk about the Palestinians or whatever's going on there with those flags? I don't know. Jim Jordan, UK authorities didn't want this censorship to be their country either, and so Keir Starmer could fix this, but the committee says there is more to come, and so we're praying for our friends in the UK. We want a strong UK and a strong Europe, but there needs to be free speech everywhere. It's the basis of existence and humanity. And so this slow march of silencing any criticism against the powers that be needs to stop. It would be nice if America wasn't the only place that had the First Amendment and other countries got on board with that and stopped this hate speech, misinfo speech crap. People died because of that misinfo and malinfo and all the things that came from our own government back during COVID and in the aftermath of the elections. They're responsible for most of it. We need to be free to be able to have conversations with real people so that we can extract the truth and live our lives accordingly without the government interfering in everything. All right, my friends, what a beautiful day it has been. And thank you for joining us from our Washington, D.C. hotel. And hopefully the internet was a little bit better. I only have 3% dropped frames today. That's great. Yesterday was like 80%. So that's good. But now, my friends, it's time to hear from you. Thank you so much for being here. Thanks for sending in some amazing donos and super chats. You guys are awesome. And thanks for joining us on the early stream as well. Let's see who's here and what is cooking as I cue this puppy up. See if we got anybody joining us on this day. It's 2:30 here. Our event, my event is in 3 hours. Okay, cool. So what's up? So that's happening soon. I got to wear a tie. I brought a suit. I brought a jacket. Your boy's got a tie on. It's been years. I don't know how long it's been, but got a tie. It's going to be a whole new experience. Now, let's take a look at who is here on the day. What's up? Rub some dirt on it. Rub some dirt on it in the house, sharing this shooting star. When you wish upon a rub some dirt on it star. Sandy, what's up? Although Grassley has been great on nearly everything the country needs, he is aiding bad Republicans and Democrats now, says Sandy. He can see what is happening by rogue judges, and his duty is to help the country in Iowa. Not on Grassley's side this time. He needs to do the right thing. Yeah, and I mean, we like Grassley a lot, but the Democrats, we've said it here, and I hate to use these analogies, man, but they they're out there like taking heads off. They're crazy, politically speaking, out there slitting throats, taking scalps. Like they'll put you in jail. They'll put you in prison. They'll create fake hoaxes on the Steele dossier. Just make it up out of nothing. Yeah, just make it up. Trump got urinated on? Yeah, just go, yeah. What? You should make it up. And they run with it. FBI, CIA, like they don't care. All we're asking Chuck Grassley to do is just like push like a couple nominees forward. Like that's all. The Democrats would do it in a heartbeat, okay? They do. They do it in a heartbeat all the time. So, why wouldn't he do it? Anyways, thank you, Sandy. And, Chuck Grassley, like, I don't know how many more terms he has either. So, let's go out with a bang there, Chuck. We're going to see him tonight. I'll have a conversation with him. I'll say, hey, Chuck, listen. We were talking about it today on the show. We like Alina Abba, just put her through. NY, what's up? Hey, E. Texley, what a great idea. Get a Jay Clayton, a money man, to follow the money. Yeah, so that's kind of what I was thinking too, is he knows that game, right? And he may be plugged in to a lot of the background on that just by being in the markets for all that time. So yeah, pretty interesting that a finance guy is the prosecutor. NY says, just listening from what the judge in court is saying about the disclosure rule, all of this rancor and negativity is a bit unfair, especially to Bondi. During Biden era, we demanded the DOJ to follow the law. Let's try to be consistent in the expectation we put on Trump's admin. It seems like it will come out, but it will take time. I think I see what you're saying, NY, and I think that's fair. Like, the DOJ, in other words, don't come down too hard on the DOJ for not releasing the documents. The DOJ has a manual, they've got rules, they don't release things, they wait for judges' approval. So like you don't suddenly shape how the DOJ operates based on a new demand, right? So kind of let it materialize and work its way through. And I think that's fair. And I think to be honest with you, we have given them that benefit. It's now 6 months. They said they had phase 1, phase 2. Like they gave us phase 1, saying that they were going to release more of it, presuming that there's 2, 3, and 4, and 5, and 6, 7, 8 phases. And they were going to release it. Like they were going to not go to a judge to get permission to do it. That was the original plan. All I'm asking for is just go back to the original plan. And then they didn't do that. They came out with a 2-page memo that says there's nothing there suddenly, and go, what? So my point in coming down on Pam and the DOJ and the FBI on this is that they had 6 months. In fact, they told us for the last 6 months they were doing all this, right? We're working hard. Dan Bongino, 6 month posting stuff, right? Posting all these things. We're behind the scenes, all this crap. Then we get a 2-page memo. Nothing happened at all. We looked at everything. It's all done. Oh, all right. And maybe that's true. Like maybe there is nothing there to this. And Ghislaine comes out and talks and she says, well, it's just me and Jeffrey and the whole thing is over. You go, all right. I could admit being wrong on that, but I think there's a lot more evidence to go to the opposite side on that. But the point is, quite frankly, I think the administration has botched the release of it. Like the memo should have never come out that way. If they didn't have anything that they wanted to share, the smarter political play, I wouldn't have been happy about it, but would have been just to let it go. We're looking at it. Just keep dangling stuff here and there for 4 years, and then just run the shot clock out basically. But they didn't. They promised us full disclosure and all the things, and they reversed it. So what's up? Hey, Mom CEO. Oh man, Mom CEO says, please pray for my mom. She's very sick and in a lot of pain. I'm sorry to hear that. Prayers up for Mama CEO. The CT of her abdomen shows a lot of kidney stones making their way out. Surgery is likely in her future to remove them all. Thank you all in advance. Prayers up for Mom CEO's mom in the house. Hopefully she gets healed up quickly. and pass those. I've heard that's not a fun experience. So sending some love her way. Thank you for being here, Mom CEO. Shout out to your mama. Geegum Geegum. Would Dugan lose her license or whatever they have to be a judge or privilege to do anything law-related profession if found guilty? So I would, if I were her, I would say no, right? My argument would be the only way you can remove me is via impeachment. So you can either impeach me and remove me, or I can, like, maybe she'd resign. Like if there's evidence that she's going to be impeached and removed, but I don't know that there's a collateral consequence on that. Like look up the other judges and how they did. I think judicial, like the chief judge could suspend you, remove you. The courts could manage it themselves, but I don't think that a conviction like in and of itself is enough to justify the removal of a judge. Now, it might justify the impeachment of the judge and all those things, and it might result in a resignation, but like I don't think it's a condition of a sentence. In other words, so it's kind of a separate matter. And if she wanted to, I think she could fight it and make them remove her, and have a good argument to do that. A good comment. Hey, this old guy says send some photos with the tie on. Definitely. So I think I can bring the GoPro over there. At least I'll do it on my phone. Record some stuff. Over from the event, we're going to. It's going to be at the Capitol Hill Club. The Capitol Hill Club, and it's cool. There's like formal rules, like house rules, guests, it's like a Washington, D.C. thing. It seems pretty cool. So we're looking forward to that, and excited to go check it out. And so Empower Oversight is hosting it. The whistleblowers will be there. Chuck Grassley should be there, which will be very cool to see. And now we're getting some other comments out, so my apologies. Let's get this queued up over here and say what's up to our YouTube friends. I see we got some new membos, some new donos. Thank you, YouTube friends. You guys are amazing. And let's get this popped out. Boom, here we are. All right, so we've got some comments right here. Boom, here we are. Over on the YouTubes. Thank you, YouTube friends. You're amazing. Hey, Relantel, it's a nice day out and you were suffering inside for us. What a gentleman. Thanks for the lip reading practice yesterday, LOL. Happy to oblige, Relantel. Happy to oblige. I'm sure it's going to happen again. What'd you think of my opening today? The membos got that yesterday. So we did a little after party yesterday, and the membos, when I came back on, they went, Rob, dork, which is true. But thank you, Relantel. Lip reading is good. Sometimes we want to make sure you're paying attention to the facial features. George Garbanzo says, Epstein had an international footprint, England, Saudi Arabia, Holland, Germany, etc. I wonder how much the trade deals are influencing the attitude about the Epstein case. Yeah, and that's the other thing. It's like there was some conversation about, well, what if let's say Epstein is what many people think it is, and it certainly feels that way. Like we also see these stories, like he won an $83 million lottery that some hedge fund was playing. Like the whole thing is, come on. And if the idea being, if there's a release of the Epstein stuff, if it is so explosive that it can undermine the entire Trump administration, like it overconsumes the rest of the 3.5 years, ends all the trade deals, causes Congress to be in total disarray, fracture into 3-4 parties, whatever, total gridlock for the rest of the 4 years, basically. You're like, does he want to do that? Not really, right? That tactically, that's not a good strategy. And maybe he wants to save that for the end or whatever, who knows? But it certainly could be a problem. Now, if that is the case, like I think from my perspective, like if that is the case, this is the moment to flesh that out. We're not going to get another Trump. There's nobody else possible who's going to, shatter that global order if it exists. And so that's kind of where we wanted to see a little bit more effort in getting to the bottom of that. Hey, Voice of the People. What's up, Voice of the People? I saw this. Our friend Joe Sweeney is back in the government now. Yeah, you remember Joe Sweeney. He came on the channel, talked about his amazing book, which was amazing, talking about Mar-a-Lago and the raid and how it was all corrupted. But he says, He's back on the Senate Intelligence Judiciary Committee this time. He can't join us for our talk of treason, though, sadly, which makes sense because he's back in the government. So maybe after the administration, we'll get to talk to him again. Good to see you, voice. This one came in from Crunchy Yellow Lion. What's up, Crunchy Yellow Lion? Hey, Mama Robo, Cody, Angel, and hubby says, congrats, Rob. Oh, thank you to the Crunchy Yellow Lion fam. Mama Robo, Cody, Angel, and hubby. Thank you, everybody over there. You guys are amazing. Thanks for saying that. Your boy's engaged now. I'm a fiance. Yeah, I think that's French, right? Thank you for that. And thanks for being membos for 17 months. Shout out to the Crunchy Yellow Lion fam in the house. Wes Downer, what's up, Wes? Good to see you. Says, I really hope the names all go back to normal when you get home. The names, because I don't recognize anyone. Anyway, I want to say hello to all my Watching the Watchers friends. Hello. Yeah, so we're streaming at a different time, so we get, you know, a little bit of a different crowd. Some people who normally can't make it join us, so very nice to see you. Meet some new faces. Indeed, Wes, good to have you here. Wes brought in 5 new membos. Thank you, Wes, for doing that. Also incredible. Very appreciated. We got Mark Shaw says, tisk, tisk, tisk. Backdoor Dugan has been such a naughty girl. Note to Backdoor, no one is above the law. That's right. No special entrances for illegal aliens. They get special everything. They stay at the Roosevelt Hotel. They get cash stipends, free food. They get air flights into the country. Then when they commit crimes, they get all sorts of privileges and benefits. FBI says, no, let them go. It's all good. Not a big deal. Are there kids in the car? Perfect. Just let them go. Will Crump, what's up, Will Crump? If Dugan gets immunity, justice in the USA is dead. UK has no control over US companies. We have the First Amendment, and we won the Revolutionary War. And don't you forget it, punks. Brit government mad citizens down police for letting Muslims attack little girls in the UK with impunity. And yeah, and then I think I saw Keir Starmer with Trump who says that no. We just censor bad things. Okay. Trump called him out. Hey, what's up, Bruce in the house? And I think that is Bruce A. Is that Bruce Rice, baby? Here, let's open this up a little bit. No, I can't tell. I think it might be Bruce Rice, baby. What's up, Bruce? Says Zoran equals Chuck Schumer becomes Anthony Corbyn, first Muslim mayor of London. Hey, I love your burqa suit. From Bruce. Is that what they're saying on the streets of London over there? Interesting times. Hey, Dark Rogue, can you mention to Grassley that we are looking for fighters in Congress who actually stand up to the Dems, who grandstand with accusations? Yeah, I would love to be able to have a conversation with Chuck. That would be very nice. I would be very nice and, I think, cordial. And I don't know exactly what I'd say, but we'd come out on the fly. That's how I go. Hey, El Durad. What's up, El Durad? Thank you for bringing in 1 new membo. You rock. You're amazing. And welcome new membo friends. I can't exactly see who you are, but we're very glad to have you here. We had this one come in from Jigum. Says, I wouldn't care. Yes, do it. Is Congress more important to the kids whose lives were ruined and exploited? Methinks not. Also, I think of the kids we'll be saving in the future. Absolutely let it blow up. Yeah, I mean, do you want to just continue on like ostriches with our heads in the sand, like having our entire society built on the back of a global ring of billionaires who just operate in a whole different world and the rest of us are just like cattle to them? I don't. And I want the people who abuse children to pay the penalty for that. And of course get due process and all the things, but we don't want 2 tiers of justice in this country. We don't want non-prosecution agreements for PDF files that encompass everybody everywhere and also immunize 4 other co-conspirators who were trafficking underage girls to him. Like, why did all that happen? Where's all the materials from the grand jury proceedings in 05 and 07? Yeah. If that exists and we're gonna fix it, this is I think probably the only time to do it. So that's why there's an urgency here, unlike other issues, I think. So, my beautiful friends, let's see what's going on over on Locals, and then your boy is going to wrap it up on the day. Get ready. Grab a little bite and get ready for the event. Yeah. Hey, what's up, Ry T? Speaking of the UK, Ry T's in the house. What's up, Ry T? Brought this one in. Says, Rob, the other day when I wasn't watching live, someone suggested a schmedium polo tux. I was doing housework when I was listening to this, and you mentioned the tailor asking if somebody broke the rule, and somehow I knew what was coming. And then you said, yeah, right. Oh, how I howled. Even though I was semi-expecting it, it still caught me off guard, and I laughed too much. I showed Mrs. Rye later, and she found it hilarious too. We love you, Rob. We love you back, Rye T. You guys are amazing. I got to meet Rye and Mrs. Rye. We had a nice lunch together, and it was a great time. Hope you're having a great time in DC. I am, man. I'm having a great time. Sorry I couldn't get the walk and talk video out before, but we'll post it after we're done here. And it's beautiful. It's beautiful. It's warm. There's like a heat warning here, I guess, for like until tomorrow. I got here yesterday. It's like, hey, you showed up. There's a heat warning today, tomorrow. He's like, when do you leave? Thursday. It's like, oh, good. The heat warning's over on Thursday. I'm like, perfect. So it's not real ideal to walk around in it. There was on the walk and talk, you'll see, there was like this couple, actually a younger couple, and it's like they looked like they were having a hard time walking around because you want to walk around the Capitol and see everything, and just, you know, you can walk all the way up and down, and I've done it. You can walk for days, but it's warm out there. In fact, my camera was overheating. The camera wasn't even staying on. It died after 20 minutes, as you'll see in the video. So anyways, yeah, not a lot of walking around, I think, right now, but the morning was nice. I think the evening will be nice, and then we have our event. Hey, Go Red Team, way better. Have good sound and audio on YouTube and locals. Awesome. All right, so yeah, I got a whole separate thing going on that. And we have, no, not at the Ritz. No, we're not at the Ritz. No, not quite. Is this like a Ritz hotel room? You know, it's nice. It's good. I'm having a good time. It's everything that we need. But hey, Chat With Me says, okay, let's go. For the sake of discussion, say that a third of Congress, both sides, is in the Epstein files in a criminal way. What do you see as the process for electing new congressmen? Would they simply function with the number they have, or would all of government stop while we had an election cycle? Well, I mean, I think, like, depending on their culpability, I think a handful of people would probably resign. So whoever leaves, I think you just have special elections for that. And then when seats are vacant, you get appointees who are filling in on a temporary basis for certain positions, and then they run for the election again. So governors, I think people would appoint people like in the Senate, and if they got indicted, they could fight their indictments while still serving, so they don't have to leave. But I think you'd see, you know, an exodus, and then you just replace those people. And if you got emptiness, then Congress would still move forward. You just have different numbers, right? So rather than a full House or a full Senate, you just have how many to get a quorum, so you could still pass laws with the number of people that you have. But yeah, and that's a great question. Yeah, while in DC, I noticed hotel Wi-Fi gets congested at the end of the workday. So your boy is trying to level up his game here, all right? So I wanted to see if hopefully this doesn't turn off the internet. I don't pull it out of the wall. But your boy got this device also over here. It's like this portable router thing. It's plugged in right now. And it's got, so right now what we're doing is I'm trying to solve this. We did not have this working yesterday, but now this is bonded. So this brings in, it's like this thing. It's got two Wi-Fis, two cells, and it bonds them all together. So right now it's connected to the hotel Wi-Fi. It's connected to my mobile broadband Wi-Fi and to two cellular devices that are not on a cell phone, you know, that are just connected to the device. So it's a little bit better. It's a little bit better, although right now it looks like it just errored out, probably because I just touched it. Don't touch my tubes, it says. Sorry about that, probably just shorted it out. All right, so that's what we're doing. Hey, and we got a couple other donos that have come in before we wrap it up on the day. Chat With Me, thank you. Jigam, thank you. Awesome stuff. And let's see what else we've got. I think I just saw something come in over on the YouTubes. Boom, I did. Thank you very much. Gary Baines. What's up, Gary? Hey, I remember the days when your stream had a female assistant. Always appreciated your insight, man. Wow, looks like a king-size bed. Yeah, that was back. So that was probably Miss Faith is who you're talking about. and she was amazing. We love Miss Faith. I hope she's doing amazingly well out there. And yeah, that was back in the R&R days. She would help me get the stream going, figure out what the hell I'm doing. So she's amazing. And yeah, it's a king-size bed, baby. So I could just spread out and enjoy. So, my friends, it has been an awesome stream. So we're going to forego our after party today because your boy's got to get ready, wrap up a couple things, and then head on out to this event. But I will be posting the walk and talk video, or we will be posting it. Hopefully the team is helping with that because my internet is just terrible. Now, even with all of this, by the way, the upload speed is still like 10 megabytes. You get like 5 from the hotel, maybe 5 scattered across the other 3, like 1.5, 2 kind of a thing. So it's interesting. So I'm still trying to learn how do these streamer bros, how do the Kais and all those dudes who are out there streaming all day have amazing connections all the time? I don't know. Got to watch more of their stuff, figure it out. But all right, my friends, it has been a beautiful stream. So we're going to wrap it up here today. Your boy tomorrow is traveling back to Phoenix, and I think I pick up time tomorrow. So we're planning on a live stream. It'll be tomorrow night, but I don't know what time I'll be back in pocket. So tomorrow night at some point, I'll fly back in, drive back home. We'll get a stream in for sure, but it will be in the evening. And so we'll pause until then. Come on back, check out the walk and talk when we get that published. I think I got a couple things to wrap up on that, and then we'll get it out and show you around DC a little bit. And then I'll, of course, be taking some pictures and maybe even some videos and seeing who else is out there today, and I will be reporting back on all of that. So we'll be gobbling up some good connections, meeting some awesome people, saying thank you to the people who really are doing some really challenging work. You know, it's one of these things like we're in it, but we're also out of it. And so to actually meet the people who had their lives completely destroyed by our own government and to be able to thank them for their work is going to be an awesome experience. So I'm excited about it. Shout out to the Empower Oversight guys for the invite and for all of the work. We'll pause here for the evening, my friends. And of course, we'll come back tomorrow to get into it again. Let me make sure we're not missing anything before we wrap it up. Sandra, great to see you. Carrie B., a Virginia councilman, was set on fire. Place the device next to the window. It's a good idea. It's a much better idea. Better than right here. Is that router connected to the incoming UFO? Yes, that one extra antenna is. Yeah, definitely. Okay, and the other thing that I was waiting to see if we were going to get today was the Durham Annex. I don't think I've seen that come through, so maybe we'll get that Durham Annex tomorrow and be able to go through that. But my friends, thanks for joining us. Thanks again for navigating some of the technical issues that we are learning about and getting an opportunity to work out. We appreciate it. So thanks for being here. Thanks for subscribing. Thanks for liking this video on your way out. Come on back to check out the walk and talk. Otherwise, we're going to come back here tomorrow. We're going to get into it again. Probably going to be a little later in the evening, but we are going to be here. And in order to do that appropriately, when we're back, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Happy Wednesday. I'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom. nothing to hide. Drop a like and don't forget to share, and bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light, watching the watchers defending what's right, watching the watchers stay each night together.